I want to first thank all of you for gathering with us for the biennial Brian Simpson Memorial Lecture in Legal History. The lecture brings together scholars to campus and reinforces ties between the law school and the history department. It honors the late Professor Brian Simpson, who was a Michigan law faculty member from 1987 to 2011. Many of you may have known him. He was internationally recognized as one of the most gifted and wide-ranging historians of the English common law. We honor him and his work with this lecture series that we started in 2015. In the past, we've brought in guests such as Dirk Hartog, Lisa Goluboff, and Annette Gordon Reed. This year, we are thrilled to welcome our distinguished guest, Dylan Penningroth. He is a scholar of African American legal history. His award-winning book, Claims of Kinfolk, is one of my personal favorites. It examines the shifting concepts of property ownership and kinship to shed light on long obscured aspects of African American life under slavery. His accomplishments are many, so I'm just going to endeavor to highlight a few of them today for you. His book won the Avery Craven Prize from the OAH. His work has been published in the Journal of American History and the American Historical Review. In addition to NEH and NSF fellowships, he was a 2012 MacArthur Genius Grant awardee. He is also the recipient of several teaching awards, and in that capacity, he will join us tomorrow to lead the Dawson Seminar for graduate students. Today, he will be speaking about his current research in a talk titled Race in Contract Law. Following his talk, we'll have about 15 minutes for questions, and then we'll gather, hopefully all of you will gather with us for a reception down the hallway in Jeffrey's Lounge. But right now, please join me in welcoming Professor Penningroth.
Thanks, everybody. I really appreciate you all coming out. Thank you, Emily. Thank you, Earl, for inviting me. I guess I also want to say thanks especially to Jenny Rickert and Alexandra Roble for making my journey here about as easy as traveling can be in these days of COVID. I'm not going to talk too long. I'm going to try to talk for less than full time. If I do, though, I hope that at least I'll have some pictures to show you, keep you awake. So one of the aftershocks of this decade's racial justice protests, I think, as we all know, is that law schools are once again wrestling with, and do I hit just the left, right keys? Oh, that works. So law schools, as many of you know, maybe it's happening here too, are wrestling over how and even whether to incorporate race and slavery into first-year courses. Now, legal scholars have grappled with the relationship between race and law for a very long time. But until recently, not much of that scholarship is focused on the place of race in contract law. Now, I think there are a bunch of reasons why it's hard to discuss race in the private domain of contract. One might be because many faculty feel relatively unprepared to discuss race. It's not something they're trained in. Another reason might be that matters relating to race are typically taught in electives and in public law courses like criminal law and constitutional law. And another reason might be that race is usually treated as context, so tangential to the substantive doctrinal rules and concepts that faced with this wave of new queries, many faculty are expressing concern that they're going to have to skimp on the doctrine just to make room. But I think there's another reason that talking about race is difficult, and it's this. It's because over time, judges and scholars have alternately played up, played down, and downright forgotten the presence of Black people in American contract law. So today I'm going to make three interlocking arguments. First, I'm going to try to persuade you that African Americans have engaged vigorously and routinely with contract law since long before the civil rights movement of the 1960s. What I'm going to try to persuade you is that state and local law were not just tools of social control, although they were that also. And contrary to how they're often depicted in scholarship and popular culture, African Americans were not alienated from law and legal institutions. Here's an example of that portrayal that you can see in the movie Selma. Instead, for African Americans, the rights associated with contract were among those that I've elsewhere called rights of everyday use. Second, I'm going to argue that precisely because federal law barred the creation of a separate body of contract law for African Americans, legal professionals over the years have frequently relied on what I'm going to call colored cases. That is, cases involving African Americans, hypotheticals and cases deploying racial metaphors and analogies, and hypotheticals in cases using theories about slavery. They've used colored cases to develop common law rules and to think through some major doctrinal and theoretical problems in contract. The third thing I'm going to try to persuade you, I'm going to try and explain what has happened to race and contract and why. So race now seems like it's absent from all but the most marginal areas of contract, but appearances can be deceiving. If you look beyond the well-known cases and standard Westlaw searches using keywords such as Negro or slave, you can find colored cases hiding in plain sight. Race has appeared and disappeared and then reappeared in Black letter law over time and at all stages of the legal process. I call this phenomenon doctrinal passing. And by that, I mean a complex interplay between the imperatives of legal advocacy, the normal flow of doctrinal distillation, and changing ideas about Black people and slavery. Similar to the way that colored people were allowed to pass as white, colored cases were passed silently into the heart of contract law and naturalized as white when legal professionals elided the fact that a litigant was Black, and when they turned slavery into an abstraction detached from race. And so what this means is that when the first significant cohort of Black law students arrived at top law schools in the early 1970s, they found a curriculum that treated Black people as a categorical exception to the normal rules of contract law, incapable and irrelevant, except as victims in the law of the poor. That treatment, which ignored African Americans' routine engagement with the full range of contract law, far beyond unconscionability, alienated Black students in the 1970s. And that's a story that I'm going to tell partly through the eyes of my mother, who enrolled at the University of Pennsylvania Law School in 1972. In short, the problem of race in contract law is not how to make room to discuss race without skimping on the substantive doctrinal rules and concepts of contract law. The problem is that some of the doctrines and concepts are not what they seem. Okay, so first, Black people actively participated in the South County and state courts during the era of Jim Crow. I'm just going to pick that era out, comes in the middle of my book, and I'm just going to try and say a few things that gives you a sense of what I mean. So I've got a large sample of trial courts collected in 4 states. I'm just going to talk for a bit about Virginia and Mississippi, that part of the sample. Black people, it turns out, were plaintiffs in 13% of the civil suits in my sample for 1872. In that year, they made up 48% of those two, Virginia and Mississippi's combined population. So again, I'm sampling dockets collected from county courthouses, and I can talk a little bit about my methods if you want later on. So 13% in 1872, 30% in 1912, when there were 44% of the two states' populations, and 20% in 1952, when there were 34% of the populations. So they're underrepresented, but not by much, in the plaintiff population in the civil courts. This is civil, not criminal. Now, Black people are using the local courts for all kinds of things. So I'll just give an example. Divorce is a major one. Insurance payouts, car accidents, railroad accidents, workplace accidents, farms, unpaid rent, personal property. They're also using law in more routine, non-adversarial ways. So They're selling easements on their land. They're making out wills and getting them probated. They're getting cars towed off their property. They're sorting out home building contracts, drunk driving charges, and landlord-tenant disputes. And of course, they're buying, selling, and giving land. Even as local white officials cut them off from the schools, the formal schooling, Black people developed a working knowledge of contract law because they dealt with it all the time. When they sold butter, eggs, and chickens to white people on credit, when they ran their own financial institutions, churches, colleges, bar associations. Black tenant farmers took pride in knowing, in having what one tenant farmer named Nate Shaw called goat sense. And I always think, when I think about that phrase, think about having the sense that God gave a goat, right? It's just sort of common sense, but his way of expressing it. The working legal knowledge, for example, and here I'm going to take from Nate Shaw, that each party to a joint note is liable for the other's debt, that a husband's mortgage did not cover household goods unless his wife signed two, and that a renter at the end of his lease had the right and privilege to take anything that ain't tied down. That's a quote from Nate Shaw. And that goat sense got refined through daily experience. It got discussed in churches, schools, and in Black-owned newspapers. Now, all this legal activity didn't challenge white supremacy. This is especially true because most of their lawsuits were against other Black people. And yet Black people clearly cared about private law, just as some critical race theorists have asserted. Indeed, even in the worst years of segregation, prominent African Americans expressed a wary faith in contract and property as a lever to uplift the race. So the AME Church Review, a religious newspaper, said, when we own railroad stock, we can have the Jim Crow car taken from the road, right? A leading minister said, buy land, be a freeholder, and no powers on earth can keep you down. In short, by removing civil rights from contract law and then conflating it with non-discrimination under federal and constitutional law, we've actually missed an enormous part of Black people's experiences and ideas about the law. For them, contract law was civil rights law. Okay, so by now you probably won't be surprised to hear that Black people's litigation in state courts began to shape contract doctrine. Cases involving African Americans are flecked across the pages of some of the leading law journals, treatises, dictionaries, and annotated codes from the late 1800s and early 1900s. And don't forget, this is the formative era of modern contract law. These authorities almost never mentioned that Black people were parties to their suits. Can't really see it, but cases shaded in blue are cases where at least one of the parties was Black. So they're not mentioning that Black people were parties. They're silently passing them into legal doctrine. And in doing so, they're stripping away facts that were vital not only to the parties, but also to the doctrinal rules that these cases establish. And of course, they're perfectly free to do so. Federal law seems to say that no state could create separate bodies of contract law for people of different races. But Congress never said that judges had to ignore race. And so ever since, legal professionals have been making up their own minds, case by case, about when race matters in contracts. In the late 1800s, when public law increasingly segregated people by race, legal professionals' decisions about race marking in private law helped to consolidate contracts as a distinct, coherent body of law. Their starting presumption was that in contract law, race had no legal meaning of its own. To borrow a metaphor from chemistry, and here I'm just going to shout out my dad who actually knows something about chemistry. To borrow a metaphor from chemistry, we might call race a doctrinal catalyst of opportunity. It became material only when it was bound to a particular rule or category. And it catalyzed arguments that legal professionals wanted to advance. This characteristic, race's characteristic as a doctrinal catalyst, discouraged judges and lawyers from considering it as a matter of structural inequality and instead tempted them to invoke it opportunistically, depending on which position suited their goals in the case. So for example, in the Slaughterhouse cases, 1873, Justice Samuel Miller insisted, quote, that the one pervading purpose of the 3 Reconstruction Amendments was the freedom of the slave race, the security of that freedom, and the protection of the newly made free citizens from their former masters. By contrast, the lawyers for the ex-Confederate butchers, these white guys who are suing to have the slaughterhouse monopoly closed down, they talked about everything except race. And so they present in their brief this potted history of oppressed white people, from ancient Romans to medieval French peasants. So the slaughterhouse cases showed that by manipulating the materiality of race, you could widen or narrow the scope of a constitutional provision. The same opportunities existed in private law. So consider Judge Jerome Frank's concurrence in Ricketts versus Pennsylvania Railroad. So in the winter of 1943, Sidney George Ricketts, he's a waiter on the Pennsylvania Railroad. He got seriously hurt on the train, on the job, just outside Newark, New Jersey. He gets advice from a company lawyer, and then he signs a paper that turns out to be a release, settling all his claims for $750. Then he got a different lawyer. It turns out he's much worse hurt than anyone told him at the time. Got a different lawyer and sued for $25,000 plus costs. And he claimed that when he signed the release, he was relying on the company lawyer's representation that it was just a receipt for his earnings and tips during the 6 months that he had missed work, and that the company will take care of you. It's a common thing, of course. Although nothing in the trial record of Ricketts says so, Ricketts was Black. The railroad's argument was that Ricketts had settled his claim by signing and accepting $750. His lawyer argued that the signed release didn't reflect the intention of the parties, right? So he's arguing for a subjective approach to formation. Ricketts himself claimed that he didn't even read the paper and did not know what was going on. The jury awarded him $7,500 and the railroad appealed. When Ricketts reached the Second Circuit, 2 of the 3 judges wanted to reverse. Learned Hand thought that under New York state law, which followed Samuel Williston's objective approach, it did not matter whether Ricketts' lawyer, his first lawyer, had misrepresented the paper to him. Ricketts had signed, he took some money, and that was that. In a series of memoranda that winter, Judge Frank managed to talk Hand into switching sides. When Ricketts finally got published, Frank used a separate concurrence to lay out a full-on critique of the objective theory in contract law, a concurrence that caught a lot of law professors' attention. He says, quote, "The modern trend is toward a special doctrine granting liberal relief from personal injury releases in cases involving extreme inequalities of bargaining power." He says, "It's wrong to treat the ordinary employee who signs away his personal injury claim as the reasonable man. An injured employee was more like a sailor facing his superior, like a captain, far out at sea. These are both people, quote, under strong economic pressures, who because of their helplessness are to be protected from hard bargains," end quote. They are, in Frank's words, under the dominion and influence of other men, end quote. They're so much weaker than their employers that free bargaining is just a mirage. And to keep companies like the Pennsylvania Railroad from using penny-ante payoffs to get out of their liabilities, Frank insisted that courts should strictly scrutinize employee releases to find the actual intention of the parties. Now, maybe it didn't matter that Sidney Ricketts was Black. After all, Ricketts was one of a long line of cases by sailors and train workers and other employees, most of whom were white. And of course, Frank did not want to limit his argument to Black employees. But Ricketts became a staple of law school teaching, just as Frank intended, and precisely because of his choices about race. In Sidney Ricketts, Frank had tapped a racial icon to be the face of the modern trend toward the subjective approach. and its frank recognition of unequal bargaining power. That icon is the railroad waiter. In those days, the waiters and porters in the big Eastern and Midwestern railroads were almost invariably Black men. And their signature role was to act as personal servants to passengers who were mostly white. In fact, the friendly Black waiter and porter were among the most, they were in fact the most visible group of American workers for whom bargaining inequality was not just inherent, but actually on display, personified in the form of personal service. Now, we've lost that context today, but to Jerome Frank and his fellow judges and law professors riding the train between New Haven and New York and DC, Sidney Ricketts' Blackness would have been so obvious as to go unspoken. Just as students today, steeped in political rhetoric about Black poverty, typically assume that the defendant in Williams versus Walker Thomas Furniture was Black, even though, like Ricketts, the reported case does not say so. Now, Ricketts' race was essential for establishing Frank's theoretical point, and yet simultaneously it had to be effaced for that theory to reach beyond race cases. Frank needed Sidney Ricketts, the man, to be colored, but he needed Ricketts, the case, to be not colored. Ricketts, the case, provided a useful fact pattern for theorizing inequality of bargaining power because being Black was integral to the railroad waiter's job, because lost tips were the main measure of his damages, and because his ignorant helplessness was the key to Frank's rule requiring strict scrutiny of workers' personal injury releases. At a moment when civil rights was becoming synonymous with a struggle for racial equality, Frank kept Ricketts in the domain of contract law by leaving implicit the fact that Ricketts was Black. Frank used this Black man's weak position to formulate a theory of assent that helped all contracting parties who bargained from a weak position. And that formulation appears today in leading case books as the paradigmatic realist approach to contract formation. Okay, so in the fall of 1972, my mother, Penelope Baskerville, became one of a handful of Black students at the University of Pennsylvania Law School. She dropped out after 3 semesters. And once, a long time ago, I asked her why, and she said she just didn't want to be a lawyer. And I believed her then, and of course I do now. And I'm sure it didn't help that she had an hour-long commute and a 1-year-old. It's me. But her grades at Penn were decent. And now that I'm teaching at a law school myself, I wish that I could ask her, what was it really like for you? So when my mom started at Penn, elite law schools were under intense pressure from students, and they were introducing new courses on topics like the legal status of the Negro in America, civil rights, and legal problems of the poor. The first-year courses were also starting to discuss various kinds of inequality, incorporating insights from law and economics and the law and society movement. But the curriculum and the scholarly movements that were reshaping it stumbled when it came to race. It tended to equate civil rights with minorities, implying that contract and property law were not civil rights. Well-meaning colleagues hardened that conceptual split when they urged newly hired minority law professors not to get too caught up in civil rights or other ethnic subjects. And so did white students who refused to talk about race in the core courses where they supposed race was extraneous. Lots of people found the situation frustrating, but it seemed as though the only remedy was more clinics, more pro bono opportunities, and vague pleas for faculty to, quote, face head-on the pain and lingering injustices of law's treatment of women and minorities. By treating civil rights as a special minority-focused body of law, the law school curriculum overlooked race's historic embeddedness in property and contract. It obscured what lawsuits brought by Black people had contributed to core areas like contract during that field's formative years, and the complex ways that contract jurists had used those cases to fashion their theories of voluntariness, capacity, reasonableness, assent, and other ideas. This was understandable because the leading casebooks of the 1960s and 70s made it seem as though contract law had nothing to do with either minorities or civil rights. These casebooks tended to recycle much of the structure and leading cases of the old ones, which had always overrepresented English cases and cases from predominantly white states. And as with the casebooks of the 1940s, even when the casebooks and treatises happened to discuss a case where African Americans were parties, that fact was getting edited out. Jerome Frank's opinion in Ricketts went into those casebooks and the Restatement second as a definitive statement of the two great theories of contract, objective and subjective, usually paired with learned Hand's opinion in Hotchkiss, or the case of the two ships Peerless, the bar napkin joke case, or the frozen chicken case. And students had no way of knowing that Sidney Ricketts was Black, or that Black newspapers discussed his case, or that Black people had been discussing contractual intent and accident releases as far back as the 1870s. When white Stanford law students complained in 1986 that Derek Bell, a Black visiting professor from Harvard, was exaggerating the influence of race in their con law course, they probably had no idea of its influence in their contracts course. Today, the only time that most first-year students read a case in contracts knowing that one of the parties was Black is probably in the roughly 20 minutes or so that they spend discussing Williams versus Walker Thomas, the unconscionability case. They cannot see the other Black litigants passing through their casebooks or the marks those litigants left on the rules they're learning. Now, it's easy to think of reasons why explicit references to race faded in the 60s and 70s. Maybe law professors got too squeamish to teach cases featuring language about unlettered colored women and inexperienced Negro boys. Those are in older versions of Casebook. Or maybe professors just weren't interested in discussing why, for example, the Alabama court is known today as the exception to the general rule barring contract damages for emotional distress. Why that court quoted at length a Black woman's suit against a roofing company. Or why Security Stove quoted from a case about the hire of a Negro slave. Certainly Black law faculty gagged at the thought of teaching old slavery era cases, like the one quoted in Security Stove, if they weren't allowed to question the basic presumptions behind measuring damages to a human chattel. So the casebook writers edited out this kind of unpleasantness by taking out the offending words or simply dropping the cases altogether. And even if they had wanted to include cases involving Black people, case reports made it very hard to spot them in the first place. America in the 1970s was still, in many respects, a post-slavery society. It was a country where policymakers thought that Black people were poor because slavery had destroyed the Negro family, that's a quote, where statutes on voting, housing, and job discrimination were dubbed a second Reconstruction, and where legal theorists continued to use slaves and slavery as thinking devices. So slavery helped herald Demset's fashion and economic theory of property rights. For Guido Calabresi and Douglas Melamed, slavery marked the limits of alienability and the entitlements that were not or could not be protected by property or liability rules. Richard Posner thought slavery proved that wealth maximization provides a robust basis for a normative theory of law, while Ronald Dworkin thought it proved the opposite. But much like the flesh and blood Sidney Ricketts, enslaved people and slavery could only be useful hypotheticals if they were not real. If they kept the veneer of history, yet were stripped of any history that might undercut the theories. And so the scholars' slavery hypos conspicuously ignored race. Some of these authors went out of their way to deny that slavery was efficient or that slavery had anything to do with race by giving their hypothetical slaves whimsical names like Roger Taney and Agatha Christie. But of course, race was central to American slavery, as the real Chief Justice Taney had pointed out in Dred Scott. And as other scholars have shown, racial slavery had once been explicit in legal theorists' thinking about the market. By dehistoricizing slavery and cutting its link to race, law and economic scholars of the 70s were not just doing bad history. They were turning away from the very link that had glowed so brightly during the first law and economics movement of the 1920s and 30s. The pattern went beyond the treatises and law school casebooks to the Restatement, which is being revised in the 1970s into what is now the Restatement's second of contracts. So the official reporters, Robert Browker and E. Allen Farnsworth, wanted to bring in some more real-life illustrations, they said, ones that busy, practicing lawyers were more likely to get. So illustration 10 of section 176, when a threat is improper, involves a contract to sell land where B, solely to induce A to discharge him from his contract duty on favorable terms, threatens to resell the land to a purchaser whose industrial use will have an undesirable effect on A's remaining land. So that's section 176, illustration 10. The reporter's note says that illustration 10 is based on a case called Wolf versus Marlton Corporation. In fact, Wolf had nothing to do with industrial use. The threat was actually to sell to an undesirable purchaser. Siddell and Milton Wolf in 1957, they were a couple, they recently separated, they wanted to get out of the purchase contract they just signed to buy a spec home in the Philadelphia exurbs. When the developer, Marlton, demurred, we're not going to give you back your deposit, the Wolves issued a threat through their lawyers. If Marlton forced them to go through with their purchase, they would resell to a buyer, quote, who would be so undesirable in your tract that it will be the last tract that you will ever build in New Jersey. At the trial, everybody studiously avoided asking the obvious question. The question that underpinned the company's claim of moral duress. That's the company lets them get out of the contract and then they bring suit. What did the Wolves mean by undesirable person? Or to put it differently, what kind of buyer would ruin a prominent developer's building career? In Central Jersey in the late 50s, it almost certainly meant a Black person. I mean, 15 years later, an hour up the turnpike, a Princeton homeowners group called the low to middle income housing project that I grew up in an instant ghetto. The New Jersey court wrote this fact pattern into the doctrine of business compulsion. The modern view, the court held, is that a threat may be wrongful even though the act threatened is lawful. We have come to deal, in terms of the business compulsion doctrine, with acts and threats that are wrongful, not necessarily in a legal, but in a moral or equitable sense. And although the judges and lawyers in Wolf versus Marlton had sent up a trial transcript that obscured the true nature of the Wolf's threat, the court's discussion of legal but wrongful threat implied that it understood the threat was racial. In 1975, the Restatement reporters picked up the case, but they changed its facts. First, it became a threat by a manufacturer to resell to the buyer's main competitor. Then it became the undesirable use, industrial use that we see today. Race was the key fact in Wolf, and the reporters swapped it out, willfully injecting a dose of transcendental nonsense into our current understanding of improper threat, and perhaps the law of duress more generally. It's easy to guess why the reporters changed the facts. Probably they thought the dispute between rival manufacturers would have seemed more relevant to the growing number of students who were seeking to practice corporate law, which was imagined by the professors as a white world. A second reason was probably that the opinion in Wolf seemed to incentivize racist behavior. In order to prevent the Wolves from profiting from their racist threat, the New Jersey court in 1959 had treated potential homebuyers' racism as a material fact to be evaluated under the subjective test. By the mid-1970s, when the restatement meetings took place, white racism was no longer seen as just a Southern problem. As white suburbanites all over America were using zoning rhetoric like instant ghetto as facially race-neutral devices for keeping Black people out. Lawyers and judges resorted to euphemisms like undesirable purchaser, city dwellers, and low-income housing. For the same reason, the restatement changed the facts of Wolf. Because civil rights activists were making racial discrimination immoral in public discourse, and civil rights statutes were making it immoral in public law, illegal in public law. But they embedded their moral revulsion against racism into the baseline entitlements and duties of modern contract law without stopping to think much about what race was or how racism actually functioned in contractual relations. The result was to reify a categorical distinction between civil rights and contract law, darkening one, whitening the other, and impoverishing both. The upshot of all this editing and case selection was to muffle what Black litigants, racial ideas, and legacy of emancipation had contributed to the development of contract law. And that encouraged white students to think of race as something that was tangential to real contract law. It treated Black students as guests to a white limestone cathedral built by white men. In the fall of 1972, when my mother opened her contracts casebook, the only reference to African Americans she would have found was criticism in the section on unconscionability of low-income marketing as an urban sharecropper system. And this veil, I think, was woven from lawyers and judges' tactical decisions in pursuit of the broadest winning rule, combined with the assumption, ironically strengthened by the civil rights movement, that Black people encountered law meaningfully only in criminal justice, voting, the workplace, schools, and public accommodations. That is, they only encountered law in cases that are about race. So what should judges and law schools do about all this? Well, one sensible place to start, I think, might be to start from the law student's perspective. Say, the perspective of a law student like Penny Baskerville. At the most basic level, legal professionals should acknowledge that contract law has never been white, and that they are already unavoidably making choices about race in their case selection and analysis. Here, I think it might be useful to distinguish two ways of thinking about the materiality of race. It's typically impossible to determine for sure whether race was material to the outcome of a given case. And I've made some limited inferences at some points today, applying my knowledge of the relevant historical context. But I think that race can also be material to the doctrinal meaning that has accrued around a case and to our choices about what a case should stand for in the future. Race is still a doctrinal catalyst, and legal professionals should try to make clear their choices about its materiality, their decisions to bind or unbind it from the rules and categories they deploy in their work. They should consider recognizing race, it's from Justin Driver, whenever it is connected to a legally cognizable harm or benefit resulting from interactions, or will enable readers to grasp the rule, concept, or approach being presented. And I think this selective recognition of race can proceed along two tracks: intellectual history and case selection. So most case books and some modes of legal interpretation are already silently organized around a history of legal thought. There's legal history right there. And they often explicitly use history as context for cases and concepts. In other words, the history of contract law in America is profoundly connected to the struggle to end slavery and the ensuing struggle to conceptualize what it means to be a free, self-willed individual in a multiracial market economy. So to an extent, the canon itself should change. Casebook authors should look for opportunities to replace cases involving only white people with cases involving Black people that eliminate the same rule, approach, or concept. But that's not the only way we can go. Casebook authors could also acknowledge which of their existing cases already feature African Americans and how deeply key concepts are soaked in debates about slavery and race. I think that this would increase, not decrease, the pedagogical power of the canonical cases. And it would reject what Kim Ford Masry calls race exceptionalism, the notion that race functions in private law as an exception, a limiting principle. Now, one might reasonably object, as Farnsworth did in 1974, that casebooks actually need fewer cases involving horses and cows and more cases involving large business corporations, since many law students, including Black students, are heading for corporate practice, not cause lawyering. And that objection might reduce opportunities to incorporate race because Black people are underrepresented in large corporations. And indeed, some casebooks seem to recognize this problem, and they've tried to adapt by adding real-life illustrations involving famous Black business people, such as Henry WorldCom, the Michael Jordan case. But it sends a troubling message if the only cases featuring Black people involve a basketball player, a boxer, a famously corrupt boxing promoter, and a welfare recipient. I'm not going to say which casebook that is. The purpose of teaching colored cases is not necessarily to acknowledge and atone for historic wrongs, as Justin Simard has argued, or even solely to make Black law students feel included. It's to convey to all students a more accurate understanding of the rules, principles, and concepts of contract law. Beyond these pedagogical questions, I'm also suggesting certain changes in scholarship. In arguing that African Americans' legal activity formed part of the mainstream of common law doctrine, the article that I'm writing builds on insights from critical race theory, but departs from it in certain ways. We should keep highlighting law's role in constructing, naturalizing, and justifying racial inequality. But it is equally important to flip the causal arrow, to explain how Black people's cases help forge a given doctrine. It's important both because it positions Black people as legal agents rather than just objects of law, and because it clarifies and illuminates the doctrine. So in sketching this partial genealogy of contract law, I'm also making a bigger argument about the relationship between law and history. Legal professionals often think of history as context, descriptive material to be ransacked to help resolve modern legal controversies. And yet, like any other legal field, the doctrinal and conceptual unity of contract law rests in part on abstracting cases from their context, stripping away what mattered. Indeed, the reported facts of the great teaching cases are sometimes so truncated, even inaccurate, that they're more like legends than the historical truth. And in law school, as in John Ford's Old West, when the legend becomes fact, print the legend. American law schools implicitly teach two important legends. The first legend is that contract law has little to do with civil rights, African Americans, or race. The second is that the history of civil rights, African Americans, and race is a story of legal liberalism and its failures. How, and I'll quote Ken Mack here, how Black communities and the lawyers and organizations that supported them struggled to overturn Plessy versus Ferguson, won a landmark victory over state-mandated white supremacy in Brown, and fought to realize Brown's promise. These two legends actually reinforce each other. The legal liberal interpretation and its critical errors triumphed by throwing away alternative traditions of civil rights, including ones rooted in contract law. Modern contract law, in turn, was created in part by exiling race to the doctrinal niche of unconscionability into other branches of law, especially criminal and constitutional law. And by taking the massive legal theoretical struggle over the meaning and limits of market freedom in a post-slavery society and turning it into abstract hypotheticals about the Negro and the slave. Many of the cases reprinted or cited today in first-year contracts casebooks were chosen during the decades between the end of slavery and the end of Jim Crow. And those cases were chosen not because they were representative or even because they were frequently cited, they weren't, but because men like Samuel Williston and Alan Farnsworth thought that they nicely illustrated certain legal principles. Jurists established contract law as a conceptually unified field, partly by burying their complicated choices about race. In a broader sense, race may have shaped the social domains in which contract was a key organizing institution, helping to demarcate contract from regulation in ways that made certain contracts impermissible, while simultaneously channeling contracts away from forms of state intervention that would have limited the domain of contract. Now, there's nothing necessarily wrong with legends, especially if they serve a useful purpose. Legal scholars, like judges and lawyers, have to be choosy in their ransacking of history. But when the needs of the legal profession change, it may be worth asking whether the particular legends being taught are still useful or not. For 50 years now, law schools have struggled to attract and keep talented minority students and faculty, and to convince them that the law being taught is relevant to them and worth devoting their careers to. And yet the leading case books make it seem as though contract law has almost nothing to do with them. And this has cost law schools dearly. The point is general. There's no principled reason why only some parts of the curriculum should be responsible for teaching about the role of race and racial minorities in law, or why students who are interested in corporate law or contracts should be taught that those areas of law have nothing worthwhile to say about race. Many law students realize this already, and they're expressing their frustration outside of class. The right to contract is a civil right, and understanding how long and how deeply Black people have engaged with the law of contract can help ease the damaging perception that racial minorities contribute only to cases that are about race. The curriculum needs to be desegregated. This might be easier than it appears. Paraphrase Toni Morrison, it only seems that the canon of American contract law is naturally or inevitably white. In fact, it is studiously so. And the canon becomes more fascinating and more powerful when we begin to notice the unspoken presence of race and how studiously legal professionals have dealt with it. Colored cases offer a useful window on judicial decision-making, on lawyers' tactics and case reporting, precisely because they obscured race. They belong at the core of our shared legal intellectual life. Indeed, more than we know, they're already there.
Delighted to say that there are many faces in this room that I don't know, and so I'm actually just gonna let you call on those. We've got about 10 minutes left if there are questions, and then after that, we'll all walk down and have a reception afterwards. Does anybody want to go first? Professor Joe.
Thank you very much for a wonderful presentation. I want to puzzle more about the Jerome Frank concurrence thing. The hypothesis is that race was important or essential for his articulating of his conception. And yet Frank is still not making it explicit in the writing, so I guess it's still within that milieu where he's sort of succumbing to the purported neutrality or whatever. And I want to know why you think that is. First of all, maybe I made that wrong. But why is if Frank has got this impulse to be like a reformer and it's important to him, why isn't he going all out there and changing the methodology of the way these cases are reported and just laying it all out there? I mean, maybe that's not a fair. Maybe we don't know because we worked with him. So.
I guess I want to be clear. You're asking why didn't Frank lay all what out there?
Talk about the role of race explicitly in his holding and advocating for a more subjective approach to interpreting contract.
No, I think it's a great question. I've been wrestling with it. Obviously, the first answer is I don't really know, right? But I can infer. I can sort of figure out what would have happened to this, not the scope, the reach of his concurrence if he had made it about race, right? Maybe another way of putting it is if he had mentioned Ricketts' race at all, it would have, in the eyes of other judges, it would have become a case about race, whatever Frank thought it was himself. And I suspect he didn't want that. He wanted this case to be about contract law generally and employee releases in accidents, workplace accidents specifically. So he starts with the release. This is an employee of a railroad. He analogizes to a sailor, quotes from an 1823 decision by Justice Story involving sailors. So he's really, he's reaching quite wide. The reason it's included in case books today is precisely because it's got this broad conceptual reach. But if he had tried to incorporate race, I suspect that it would have been removed from the domain of contract law, or at least it would have been, it would not have been as prominently featured in Casebook. Let's just put it that way. Does that make sense?
Yeah, no.
And I think, you know, if he really wanted,
marginalized.
yeah, he wanted to make it a big case. He'd been angling up to that.
Yeah, thank you. This is really fascinating. I was wondering, I mean, it seems to me that the argument, some historian makes perfect sense, but of course it also goes further, right? Because it's not just about race, it would be gender, it would be a whole set of identities. And so it does bring up the issue, which is probably about the kind of essence of legal training, which is if you turn it into a specific, a person in a given place and time, lodged there with all the complexities and extraordinarily, you know, sensitivities and peculiarities of that place, then how do you teach lawyers or law students to read it as something that is both specific and general, to move in and out, right? Which I take it is, in the end, one of your deeper points, that it's the need to be able to do both, that to just extract it into a universal misses the fact that it never was and never will be. But of course, if it remains too much and lodged in all those particularities, then every move out, every attempt to take a new precedent becomes a new question and a new issue. So I'm wondering how you're thinking about an entire practice of reading that allows that movement to be not just kind of frictional at every moment, but somehow smooth enough to work, but frictional enough that you keep on having to come back.
No, I think it's a great question. And, you know, I honestly think that here we don't need to reinvent the wheel because, you know, all the cases, you know, they choose certain facts to reproduce and they exclude other facts like that, right? Like it doesn't matter. It's not material to the judge and it doesn't matter to the casebook. Say what time of day the block of wood fell on the, you know, the owner's head in Webb versus McGowan, right? But, you know, but it does matter that it was a block of wood falling from a second story because, you know, the man who threw himself, you know, it helps the jury and the judge understand what actually happened in the case. So, you know, facts are always getting included or excluded. We're always already making choices about this stuff. So I guess my instinctive answer is we've kind of got many of the tools that we need already to do that. And, you know, maybe, I mean, it may not be enough, but maybe one thing to do is just to sort of look and see what's already there and learn enough of the historical context to be able to make good decisions about when to include it. So I'm not saying that every time it's necessarily going to be useful for teaching, but we should be mindful about what we're doing when we don't include it. Does that make sense?
I mean, it might be a question of salience, right? When is that particular identity function salient to
the issue, to the thing that you're trying to do at that moment? So if you're a judge, it might be this. If you're, you know, standing up at the podium, it might be that. You just think about what it is. But the first step is just to know that it's there in the first place, I think.
Oh, thank you for the talk. Brings up a lot of interesting issues. I just want to sort of just put quickly just two on the table. One just relating to the exact charge you have against the textbook authors. One is related to the charge that you have against textbook authors, and the second is related to your concept of doctrinal passing. So just quickly on the first point. Towards the end of the talk, you sort of said that, look, I want to make it the case to where these textbook authors are no longer making the case that these textbooks are merely about white people, but they also want to include Black people. And I sort of thought, well, I don't know if they're actually doing that, right? Like the thing that they're doing is just being neutral on race, right? They're not actually talking about race at all. So it seems like somewhat misleading to say that they're making these case books about white people and not sort of including Black people. Like, no, now this happens in a context in which we live in a society where the default is whiteness, and for that reason, by not saying anything, then the assumed presumption is that both the plaintiff and the defendant is Black. Maybe that's the point, but I just wanted to sort of get clear on exactly what the charge is, because of course their response there is just, look, we didn't say anything about race. It's not our fault that the reader is making an assumption that a particular race exists, et cetera, et cetera. So that first point was just like asking for a brief clarity on what the charge is against the textbooks authors. And then just briefly second, the concept of doctrinal passing, I find this concept fascinating, and I thank you for sort of introducing me to it, but I just wanted to see that, like, in various ways it seemed to go away from the traditional concept of passing. One sort of big way, I can think of a number, but one big way is that with the traditional concept of passing, it typically occurred when an individual was trying to avoid the majority or the persons in power knowing their race to avoid, to not receive harmful treatment, right? So whether it's like to receive a job, not have to ride the back of the bus in Jim Crow, Georgia, et cetera. The whole point was that the individual was making it and distorting the people in power, whereas the concept of doctrinal passing seems to occur another way, right? The people in power are doing the distorting, right? So it's the learned hands of the world, or the textbook authors of the world. Like this, it seems to be a mismatch, or at least a flip to where, Ricketts or Walker isn't the person that's really trying to pass, right? They're just putting their case forward and trying to win. So I wonder, like, what does that do for the overall concept of passing, where it's not really the individual that's trying to distort the people in power, but the people in power sort of doing the distorting?
Thank you. Those are great questions. What am I saying about what's the charge against casebooks? I should probably solve my language. I'm not charging. I shouldn't seem that I'm charging them with a crime or offense or anything like that. I think of it more as sort of constructive criticism. Never having written one myself, I probably never will. I think you're right that a casebook author would probably say, look, I'm just not talking about race. And if you think that the casebook is coded white, that's sort of in the eye of the reader, right? It worries me to embrace that position too much because it sounds so much like what Justice Brown said in Plessy, right? Like, the reader's perspective does matter. And I think Black students are probably not alone in assuming, and maybe even bristling at the implicit message being sent by a casebook that never acknowledges the presence of race or Black people except in this one little spot. Does that make sense? So that's the answer to the first question. On the second question, I think you're absolutely right. You put your finger on, one really important difference between doctrinal passing and just regular old passing. And that's the issue is volition. Cases don't have volition. People make cases do something. So that might seem like a hard and fast distinction. On the other hand, I wouldn't overdraw the volitional capacity of people who pass. Sometimes people get passed unwillingly. People may be in a certain place. They are not desiring to avoid anything. They're not desiring to be read as one thing or the other. They want to be read as Black, and yet they are not. So I think that you're absolutely right, but I want to be careful not to overdraw the distinction. Cases have no volition. People do have volition, but not complete agency over how they are perceived by the world. Does that make sense?
We are ready for snacks. So everybody, because they're putting on another.